I'm happy that you came back from the coffee break and that we've made it, because it's a hard task to chair the last panel. I know that you are all tired about the hot weather here in Florence, but I will try to be brief and make this discussion as lively as possible. I already agreed with my colleagues. We will try to respect our time constraints because we are already late. So this last panel is about the protection versus the sharing of personal data. We have been talking of this aspect, but also about other several aspects regarding sharing of data. We have here 4 brilliant panelists. One is joining online. And although we have also them have all a legal background, they will offer you different perspectives on the subject, since they come from different institutions, private sector, academia, national regulator. So we have different perspectives on the issue. I will start with a general presentation. Then for a question of organization of the session, I will start with Dr. Björn, and then Mrs. Katie O'Leary, then Marco, and the last panelist will be Professor Michèle Finck. And that's it, let's start. And well, you already read it probably, but I'm a researcher at the Center for a Digital Society, and I'm somehow specialized in data protection law. And our aim today is to discuss this kind of dilemma between protection and sharing of personal data. So I will make a brief and general presentation. Data protection and regulating the processing of personal data used to be a question of protection of a fundamental right, someone called the fundamental right to privacy or to the protection of personal data, and to allow the free movement of data within the European Union. So we had the first EU directive 46 from 95 that had as an objective these two main aims. And then came the GDPR with the more or less the same aims. But with the digitalization or the digital economy, we have now other things that impact the regulation of data protection. So we have, on one hand, the processing of huge amounts of data, and on the other hand, the process of data monetization. So what happens in this new scenario is that we have the interplay. We have been talking a lot about this morning and in the previous session about several fields of law. We have anti-discrimination law, for example, the AI Act talks a lot about anti-discrimination. We have data protection law, interplaying with competition and consumer law. So we have personal data as the object of several pieces of legislation within the EU regulatory framework. And a very good example is the new regulatory framework for the digital economy. So we have personal data in the DMA, DSA, the Digital Governance Act that Professor Michèle will touch upon. And we have the AI, and the Data Act that are still to come in the near future, but they also regulate somehow personal data. So my question for this session is, what's the right balance? And more or less, I go back to the question that Professor Scott this morning mentioned about private incentives versus the society welfare. And not only, I have a further question, what's the right balance, but how to achieve this balance, which is more, I think, challenging than. So I open the floor to the panelists. I will give the floor to Björn, who will somehow talk about the interplay between these several fields of law regulating data protection. Please.
Thank you, Danielle, and thank you, first of all, for the invitation, and thank you for the great conference so far. Very, very interesting discussion. A lot of points. I took notes. I can touch upon in my short presentation. It's great that you put on this slide. I think this is really this is a great illustration of the topic we are discussing. This data sharing, and we heard a lot about the positive effects about this data sharing. And data protection. And Laura used the expression a couple of times in her presentation. She talked about clashes between the different pieces of regulation. I also had this in mind. That's really a clash we have here between the data protection and data sharing. If you start with the data protection, this is consumer protection law. So the basic idea is that every individual should have control of his or her personal data. And as Danielle rightly pointed out, this is considered a fundamental right, something we Europeans hold very dear, which in the meantime has also been adopted in other parts of the world, but this is really a centerpiece of European right. And to put it a bit less positive, maybe the basic assumption in my view, and there are bigger experts on data protection or privacy law here in the room, but my feeling is always the basic assumption of data protection or data privacy law is that that personal data should be processed as little as possible by third parties. So the best outcome is if personal data stays with the individual. So at least there's a very healthy skepticism towards the sharing and handling of personal data by third parties. Now, the Magna Carta of EU privacy law is, of course, the GDPR, and based on this skepticism, the GDPR, in my view, imposes very high hurdles for the processing and the sharing of personal data. There's another question whether that's always respected, but at least the law is, in my view, very strict. For processing of personal data, you need either require a legal basis or consent by the individual whose data you want to process. And I'm just that's the only piece of legislation or legal text I will read out. But I think it's really central to keep in mind that under the GDPR, consent of the data subject means any freely given, specific, informed, and unambiguous indication of the data subject wish, by which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of personal data relating to him or her. So this is a very, very high standard, and I think a lot of people appreciate that we have this very high standard. On the other side, if you are in a situation that you want to, as a company, process personal data, this very high standard confronts you with a lot of legal uncertainty. It's a question, do you have a sufficient legal basis? Is the consent sufficient? And you need it for, as I just read out, always for just one specific purpose. So you can't have a general consent on the processing of data. Plus, and if you have read the confirmation email from the conference, they also process your personal data. Of course, they say that you can at any time withdraw your consent, and then you are without a basis for the processing of the data. So the aim is clear, but it's also the effect is that you have a lot of legal uncertainty. So Because we are in Florence, I try to put this in the categories a bit of the Divina Commedia. So there's I think for privacy lawyers, the processing of personal data, that's something which should be allocated in the Inferno. Now, that's the first world, which is now, I would say, clashing with the second world. And this is the second world where, and this has been explained over the day already a couple of times, data is considered as a competitive parameter and will be, or should supposed to become under the Data Act, the basis for a new data economy. You can calculate the billions the EU wants to create with this data economy. I want to not use the example of data as the new oil, because I think it's not really accurate. But anyhow, there's a lot of emphasis on data, and we've heard about this in the last panel. And I can really recommend the OECD study that Antonio mentioned on data as a competitive factor, or a factor in competition assessment. So this world is the world of, and I think I agree with the other panelists and from the earlier panels, you don't really have to distinguish between here competition law, and regulatory law, and then market regulation law. This is the world where, in principle, data sharing of data can be something positive. And in this world, there's really in the first step no distinction between personal data and industrial data. So if you talk to a privacy lawyer, they always talk about personal data. If you look at the data economy, the starting point is first it's data. It's something you can create something out of. And then in the second step, maybe if you look at the conditions under which this data can be used, then you find out, okay, it's personal data. We have to keep something in mind. So there's in this moment, this happens here. What you see on the slide, you have the data sharing. You want to be part of this new economy. You start sharing data, and then there comes this roadblock, the data protection. And because GDPR has been perceived as such a success story, it has very strong support with EU policymakers and lawmakers. So very often in this new legislation, you will simply find the statement: the GDPR prevails. So, for example, in Data Act, there's a clear statement. We don't need to talk about the relationship. GDPR prevails. Something which is, as a competition lawyer, say, you need to get used to, because normally competition law prevails over everything. Now you have to somehow see how to resolve this clash situation, where you have to respect also the GDPR. And in my view, there are two basic scenarios or situations you need to distinguish. The first is, and that's something which has been mentioned in the earlier panel, is the competition law parts, where the processing of personal data can lead to an abuse or to an infringement of competition law, or so it generally could be also where the possible negative aspects are considered. So basically, there's a part of this data using world outside of the GDPR where the skepticism of the GDPR also applies. That is wherever you're looking at the abuse of dominance, or at the conduct of strong companies. I would say also these parts of the DMA which concern fairness. So this is, for example, you have the Facebook case in Germany, where infringement of the GDPR were also considered an abuse of a dominant position. This is pending at the moment at the ECJ, but there has been the opinion by the General Advocate, and it seems supportive of the view of the German Competition Authority. So infringement of GDPR is at the same time a competition law problem. It goes in the same direction. The same with Article 5.2 of the DMA. And I think Marco will shed some more light on this. So I will just mention that it poses restrictions on data combination, but with reference to the GDPR. So if there's consent under the GDPR or in line with the GDPR, there's then this processing of data or the combination of data would be possible again. So in this part of the data world outside of the GDPR, I think we are more or less in line with the GDPR. Basically, there's more the question of the interplay between in the enforcement and the interpretation of the GDPR rules. At the moment, the data protection officers are a bit on their own, but they will become now in enforcement by competition authorities and by the Commission enforcing the DMA, because basically infringing the GDPR can also lead to an infringement of the DMA or of competition. So the key question, in my view, is there the sufficient alignment and cooperation between these authorities, but in principle, this leads to a strengthening of the GDPR. The more, I think, challenging part is the second dimension. So where we say the access to data is not something bad, but this is part of the paradiso. So we want to open markets. We want to tackle the data advantage of incumbents, of strong companies, of gatekeepers, by giving data access, and we want to create a data economy. And this concerns not only industry data, but also personal data. And then we have the conflict with the DMA. So we have the data access rights under the essential facility doctrine. It's also specific regulations, for example, in German competition law. You have it in the DMA in Article 6. 10 and 9, there's also, of course, now the Data Act. And the principal idea is it's good that third parties will be granted access to data so that they can build their own business on basis of this data, that they can challenge the companies which already are in possession of this data. And then at this point, I think there we have a friction with the GDPR. Which makes very often these will, in my view, make this data access very difficult, if not impossible. Just to give one example, if you look at Article 6, Section 10 of the DMA, which gives a data access right, and in principle, the third party could claim data access from a gatekeeper. This gatekeeper still would need to respect GDPR and would have to get consent for providing access to third parties to personal data, something which is, in my view, nearly impossible. So the question is, and that's my last sentence, is the GDPR in this form fit for the data economy we want to create? Or do we in the future also, if we want to build further on this data economy, need to amend the GDPR?
Thanks a lot, Björn, and sorry for making you run a bit, but we are. So I will now pass the floor to Katie. She will give an overview from the Irish Competition Authority on this interplay between data protection and competition law. Yes.
Thanks very much, Danielle, for the introduction, and thank you for inviting me here today. So just to confirm, I'm here representing the Data Protection Commission. So I will discuss the areas where the Digital Markets Act interacts a little bit with the GDPR, and I will also discuss the obligations on national authorities under the DMA other than competition regulators. In Ireland, the CCPC regulates competition law, so I can't speak to what they will, what their interaction with the Commission will be like, but I will address the points of overlap between, or some of the points of overlap between the GDPR and the DMA. So the first point to highlight, which follows on from what Björn was saying, is the DMA is stated to be without prejudice to the GDPR, and the obligations under the GDPR will therefore continue to apply in parallel. There are naturally some areas where there's a very direct overlap between the GDPR and the DMA, which one of those is Article 5.2 of the DMA, which I know that Marco is planning to talk about also. So Article 6 of the GDPR sets out a list of 6 potential lawful bases for processing personal data. One of those 6 is consent, and in any the way the DPC interprets Article 6 is that in any specific factual circumstance, the controller must demonstrate which of those 6 lawful bases applies to the processing. The DMA creates a specific obligation on gatekeepers to obtain consent in the circumstances set out in that provision. So the DPC will need to apply interpretative principles such as lex specialis, lex generalis, as it arises in any specific context where there's that overlap in the factual circumstance that the DPC may be investigating in the future. Naturally, the DMA obligations have not yet started to apply to gatekeepers, so we haven't dealt with this point in practice yet, but we have dealt with applying interpretative rules to principles-based legislation in the past. So I was planning to share just a little bit about our approach to interpreting and regulating that kind of legislation, which might be relevant to the discussion on interpreting these new piece of legislation that are coming down the track. So the DPC, we received maybe a lot of coverage over our enforcement activity, the large inquiries into technology companies. It's important to highlight too that our role also involves providing guidance. On the DPC's website, you can find lots of guidance about interpreting data protection law, and similarly, the EDPB produces guidance on that also. Court judgments are very useful to us when we're interpreting the law and applying it in addition to that guidance. And we also take on a supervision role where people can come to us and ask us questions about the application of data protection law. When it does come to enforcement then, in addition to court judgments, we look at legal principles and the overall effect, the overall aim of GDPR legislation, and use those to interpret and apply the law. So then turning to the times when the DMA and the GDPR may interact with each other or potentially come into tension. The DMA specifically imposed an obligation on national authorities to ensure that their decisions do not run counter to a decision adopted by the Commission. And the recitals to the DMA specify that national authorities must have regard to principles such as proportionality and the nivus in idem principle also that was mentioned earlier today. So if the DPC is investigating a specific factual situation that has already been subject to a factual investigation by the European Commission, that's something that we'd have to be conscious of. By looking at any DPC decisions, you can already see that we're very conscious of these principles. When the DPC issues a fine under Article 83 of the GDPR, we're required by that legislation to consider the principle of proportionality. And if you look at our decisions, you can also see that we are very conscious of the principle of nibis in idem, which prevents us from sanctioning somebody twice for the same conduct. There are also provisions in the DMA relating to cooperation between national authorities and the European Commission. So there's much more fleshed out provisions relating to cooperation between the Commission and competition authorities. By contrast, Article 37 doesn't include a lot of detail about what the cooperation between other national authorities and the Commission will look like. The Commission may adopt implementing acts relating to the practical arrangements for that form of cooperation, but to the best of my knowledge, none have been adopted to date. But again, we've experienced cooperating with other regulators in various contexts. Most particularly under the GDPR, we cooperate with other regulators across Europe through the mechanism set out specifically in the GDPR. We also deal with, even where the DPC acts as a regulator for different pieces of legislation, there are often different enforcement mechanisms set out. So we're conscious, for example, when we're regulating the e-privacy directive and it's implementing legislation in Ireland, that there's a different enforcement and sanctioning regime for those pieces of legislation, even where the subject matter can overlap with the GDPR. And similarly, we cooperate with the CCPC in Ireland, the Competition and Consumer Protection Commission, where necessary in relation to the overlap of their regulation of online content moderation and our regulation of GDPR concepts such as the right to be forgotten. So going forward, we would rely on that experience to cooperate with the Commission as required under the DMA, and some of the role of the DPC might be to assess where people claim that they can't do something under the DMA because of the privacy requirements of the GDPR. Björn talked about that in his speech already, about how the GDPR may appear to prevent obstacles to compliance with the DMA. So we would envisage that part of our role will be to cooperate with the Commission in relation to those types of claims. Also, another mechanism through which we can work with the European Commission at EDPB level. So the EDPB is the Board of Data Protection Authorities across the EU, as I'm sure you all already know, and the EDPB is one body that's represented on a high-level group that's been established under the DMA, and the Irish DPC acts as one of the EDPB's representatives on that high-level group. The first meeting of that group took place last month, or earlier this year in Brussels, and that group can give advice to the European Commission on their implementation of the DMA. The European Data Protection Board has also recently established a task force on the interplay between data protection, competition and consumer protection, and that task force may in the future provide guidance and expertise on the interplay between those different legal areas. So that concludes what I wanted to say, and yeah, I'm happy to hear what the other speakers have to say, and any questions at the end also. Thank you.
Thanks a lot, Katie. Very good insight on what an NRA can do during the implementation of the DMA. Though the data protection authorities will be probably not so involved as the competition authorities. So let's move now to please. I think that Marco will touch upon the question of consent under the DMA. So happy.
Thank you very much, Danielle. Thank you very much for having me today. It's a pleasure and honor, and also to follow great speakers like before Professor Siragusa that really inspired me with some very important thoughts around DMA. In a much more humble way, I will try to look at Article 5.2 and more in general DMA and the way a company like Meta is approaching compliance with this very important piece of legislation. So first, we need to start from an important consideration, which is that the two main pieces of legislation that we are looking at today, GDPR and DMA, are coming from very different place, and they want to land to a very, very different place. GDPR is the data protection regulation, which not only is there to protect user fundamental rights and data, but also are creating the framework in order to make sure that this data can flow in a way which is lawful. The DMA goal, as we heard today, is about market fairness and market contestability. So they are trying to address, and they're coming from this place, specific market concern. Now, when we look at complying with these two pieces of legislation, we right away can see a first challenge or opportunity, which is try to square the circle between two different needs and try to address two different problems in a way which is not degrading user experience. Why I'm talking about user experience? Because I think it would be completely unfair if I'm approaching the topic of complying with the legislation without making as a clear premise that a company like Meta, which is serving with its services and connecting with its services million, sometimes billion, if we look at globally, users every day, should do this without taking consideration to maintain a positive experience for the users. It's our duty, and we of course don't want to degrade the experience of the users in complying with legislation. So how to make this happen? That's the real question that we have in front of us, because for sure we want to comply with legislation, for sure we care about user fundamental rights, for sure we care about also market contestability. We need always to remember that meta services, and if we start from the first and most notorious one, Facebook is an application which users install on their computer or on their phone, but does not have any legacy relationship with the users, so rely on an ecosystem that is created, that was created years ago when the internet was made, which is made of browser, which is made of operating system. So it's really in our interest, in one of the core values of meta openness. So once again, how to square the circle? And the only way to square the circle is to try to analyze different problems that the DMA is putting in front of us, and looking at this, we need to look at this problem in taking always in consideration what is the relationship between these problems or opportunities with the existing also legal framework like GDPR. Questions that we have in front of us are including impact of compliance with integrity, safety, data security, fraud prevention, and consent fatigue. And let's look in particular on some of them. So first, the interplay between GDPR and DMA, and here I will not do anything more than repeating what Katie and, for example, Professor Siragusa said, that of course we consider DMA not as lex specialis vis-a-vis the GDPR. The GDPR is there, the GDPR is the legislation that we need to consider when it's about user data and the way we can allow a user to flow in a way which is lawful. That said, the mechanism that Article 5.2 is considering in order to allow companies or gatekeepers that wants to combine data or cross-use data across different CPSs is consent. And here the first consideration is that the legislator made a clear choice to pick only one of the legal bases of the GDPR, consent. While when we look at the same issue, legal basis, in order to allow the process of data under GDPR, you have different legal bases, which of course include consent, but also legitimate interest and contractual necessity. And from different decisions from the Court of Justice and from interaction between companies like Meta and the regulators, it is clear that there is no specific preference in the GDPR between a specific legal basis. So first, this challenge, how to make sure that we can continue on one side to rely on the different legal bases of the GDPR, and on the other side, we need to apply consent when we, as gatekeepers, are going to cross-use and combine data across different CPS. Here, the only way to look at this, in our opinion, is to have a pragmatic and factual approach to consent, which has to take in consideration two elements. The first element is the element of consent fatigue, which is a very important element that has, in our opinion, also to become one of the criteria that has to be used in order to consider if DMA compliance is fit with the purpose of the legislator. So on this, and on the other side, making sure that this, of course, is in line with what the GDPR says. Once again, here I put it as a question mark in approaching to this specific view of consent. Should we also not consider the possibility of combining different consent in order to avoid that, for example, users that has to go through different, which are using services that are different CPSs and are required to give consent multiple times a day? I'm sure that that's something that we will have to discuss with the regulators. Second is a matter of effectiveness of the mechanism of Article 5.2. Why I'm calling this effectiveness? I'm sure, and once again, I'm sure that this is also in the mind of the legislator. While the goal of improving market contestability and market fairness has to be there, the legislator didn't have in mind to reduce the level of protection or security or safety of the users in, for example, using services of gatekeepers online. And here will be another challenge that we will have to discuss with the regulators, because of course we are not seeking for any exception, but I'm sure that, and that also coming from public conversation with the regulators, that is not in the interest of anyone, including the Commission, that, for example, safety is degraded, or even fraud prevention is not permitted because of the complexity of collecting consent from who is actually trying to commit a fraud online. So all these are problems that are on the table. I think if I wanted to take further the comparison of this legal framework to Dante Divina Commedia, all the gatekeepers in this moment are in Purgatorio, which, by the way, was an invention in the Middle Age created by the Church in order to extract value from the believers. So it's an interesting, could be an interesting comparison to expand, metaphor to expand. But once again, we are in Purgatorio. We're trying to do our best in complying with these new rules. I want really to close by telling you that our challenge at the moment and opportunity is to comply with these rules, making sure that on one side we are improving market fairness and we open the market, but on the other side we don't make the experience of the users worse.
Thank you very much, Marco, for exposing the challenges with the implementation of consent in the DMA. Now we are finally moving to our last panelist, and I'd like to apologize for the delay, Professor Michèle. We are moving also to a different topic. We are going to talk about the Data Governance Act and also the interplay between data protection and sharing of data, in the role of intermediaries in the Data Governance Act. Thanks a lot.
Thank you so much, Hugh. Thank you so much for having me this afternoon, and also for allowing me to participate virtually. Needless to say, I would much rather have been with you in Fiesole today, but unfortunately that was not possible. So since I'm switching gears, and since I'm going to talk about the tension that we see arise between the GDPR and the Data Governance Act, maybe let me start by saying a few words about what the Data Governance Act actually is. So this is a new regulation that forms part of the broader data strategy of the European Commission that has been pursued over the last couple of years. It has entered into force. I think tomorrow it's going to be 1 year since it's entered into force, and the Data Governance Act will become binding in September 2023, except for the regime on data intermediation services that I'm talking about today, which will enter into force later, I think 39 months after the general becoming binding of the regulation in September 23. Now, the Data Governance Act in general seeks to create different new legal regimes that seek to incentivize the voluntary and trustworthy sharing of data in the EU. So I think one of the broader differences with the Draft Data Act, for instance, is that it focuses on a set of voluntary data sharing mechanisms. And one of the new legal regimes that have been created by the Data Governance Act is a legal regime for data intermediation services. Now, what is a data intermediation service? We find this definition of in Article 2, paragraph 11 of the Data Governance Act, which defines data intermediation services as services that aim to establish commercial relationships for the purposes of data sharing between an undetermined number of data subjects and data holders on the one hand, and data users on the other, through technical, legal, or other means. And in Chapter 3 of the Data Governance Act, we find a number of procedural and substantive obligations that data intermediation services need to meet in order to obtain this logo that's foreseen under the Data Governance Act, and which will presumably increase trust in those services. And when we study the obligations enshrined in chapter 3 of the Data Governance Act, it becomes clear that in the future, there'll be a number of tensions that will arise between this new regime as well as the GDPR. And I think the sort of most important of those tensions, or one of the reasons why those tensions will materialize, is because the Data Governance Act enshrines a presumption that it is possible for data intermediaries to have awareness as to what data they intermediate. We find this in different provisions of the Data Governance Act. So for instance, the Article 12, 1L, creates different levels of cybersecurity obligations that data intermediation services need to meet. And these vary depending on the data at stake. So there's a general presumption that it is possible for data intermediation services to have awareness of the legal quality of the data that they're intermediating. And this is certainly also the case regarding whether the data that they intermediate qualifies as non-personal data under EU law or as personal data under EU law. And of course, where personal data is concerned, the GDPR applies. Now, the first question I guess we need to ask to determine the practical implications of this is to ask whether data intermediation services qualify as data controllers in relation to the personal data that they intermediate through their technical, legal, or other structures. And here, the answer, I think, in many cases will be a clear yes, right? So to determine whether someone qualifies as a data controller or not, we need to look at Article 4, paragraph 7 of the General Data Protection Regulation, which tells us that a natural or legal person that determines the means and the purposes of data processing qualify as data controllers. Data intermediation services will, in most instances, determine the means of the data processing operation, that is the data sharing, such as where they create or make available the technical infrastructures through which sharing occurs. And they also determine the purpose to the extent that the purpose is the intermediation. And we find various provisions and recitals in the DGA in which intermediation is indeed explicitly qualified as a purpose. And the presumption is that the European legislature didn't want to create different interpretations of this terminology, so that this purpose in the sense of the GDPR is probably also a purpose in the sense of the GDPR. Now, why will this be a problem in practice? This will be a problem in practice because most data intermediation services, as they exist today, will struggle to actually be able to determine the legal quality of the data that they intermediate. This will, for instance, be the case where there's no central storage of the data, but where all the data intermediary does is create an infrastructure that allows party A to access data from party B without the data ever passing through the data intermediary. So this would, for instance, be the case in various models around federated machine learning. And they will also struggle to determine the legal quality of the data that they intermediate, where the data is encrypted, and they only receive data in the encrypted form without also having access to the decryption keys. So looking at this, I think it becomes clear that going forward, data intermediaries are faced with legal obligations that they will struggle to meet. It is true that data intermediation services are still, there's various forms of data intermediation services. They have different business models, different mechanisms of enabling the intermediation. But many of them, I think it is fair to say, will struggle to meet this obligation of determining the legal quality of the data that they intermediate, because the way in which their operations occur simply prevent that. In addition to this, there's of course the general problem that the legal qualification of personal and non-personal data is very difficult. There's been many examples of this in recent years, and lots has been said in that respect. So I'm not going to go into detail here, but it's certainly worth mentioning that this general problem of determining what is personal data and what is not personal data will be a challenge in this respect. And I think it's fair to say also a challenge in respect to all of the different regulations that we're seeing emerge in relation to data in the European Union. Then I think there's an additional sub-question to this broader problem that's also worth quickly mentioning, namely that the Data Governance Act leaves open the question of whether it is for the data intermediation services to themselves actively determine the quality of the data that they're intermediating, or whether they can trust statements made to this effect by other parties, such as the data holders that provide them with the data. And I think all of this really underlines that there will be significant tensions between the Data Governance Act and the GDPR going forward, this being one of them. This is maybe not surprising, if we think about the general nature of these two legal frameworks. The GDPR is a qualified prohibition on the processing of personal data, whereas the DGA and other components of the broader digital package or legal frameworks that really seek to incentivize the sharing and processing of personal data, right? So if we keep this in mind, it's certainly not surprising that we're seeing all of those tensions emerge. But yeah, I think we can expect petitioners and courts to remain busy with resolving those tensions in years to come. And I see that I'm running out of time, so I'll stop here, but I'm very much looking forward to the discussion today. Thank you so much.
Thank you very much for this interesting presentation. And we move now to the questions, and from the audience, from the online and the audience here on site. So please feel free to ask our panelists, and yes.
Christian Ramsbach from the OECD. I have two comments/questions. One in respect to the general statement that data protection is basically in conflict with the concept of data sharing. And here I would like to hear your reaction to the following thought, which is that maybe this apparent conflict is due to the fact that how it's related to how we understand what privacy is about. Essentially, yes, you can understand privacy as data, and I emphasize protection. And obviously, when you say protection, you mean you keep things closed. But you also can understand privacy as informational self-determination, basically putting the individual in control. And depending what aspect you want to emphasize, you may come eventually to different conclusion. And here I would basically point to the tomorrow's session, so this is a little bit of the advertisement, on data portability, where the argument is clearly that by empowering individuals and allowing them to control their data, they will be in the position to decide what to do with it, meaning they can decide to share or not to share. So therefore, that distinction may be, or that conflict may not be as strongly as we have presented this. And by the way, this would eventually also explain why there is such an emphasis on consent, because this is the traditional mechanism for giving individual control. And the second question is addressed directly to Ms. Finck about the the role of intermediaries. And here I would like to understand, would you agree that one of the fundamental challenges that we face here, in particular in respect to consumer-facing intermediaries, is that we still don't have a sustainable business model for those intermediaries, meaning there is no willingness probably among individuals to pay for intermediation services.
I also have a question here on the chat. I will read it out loud. To your understanding, what does the specific choice as outlined under Article 5.2 DMA mean? So probably this question would go to your understanding, what does the specific choice as outlined under Article 5.2 DMA mean? Who would like to start? I'd like to, I'm not supposed to, because I'm just a moderator, but no, on your comment about, I don't know if you were referring to the metaphor about the Dante, or about the slide on the balancing, but I see your point, and I think that data protection is not in contrast with data sharing. What I say is that data protection for me is a safeguard that allows data sharing in a secure way, let's say. And so what I'm saying, what I tried to say is that how much should we allow for data sharing, and how is the right balance in terms of regulating both sides. Okay, but please, the other panelists.
Yeah, maybe if I can also reply to your comment, and maybe I was stricter on the on the conflict. Yeah, I think you're right. It's of course it's not a definite contrast. You can share data in a safe environment. My feeling was just, and that's also because of the history of the GDPR, that it comes from a time where it was not really envisaged that it would be on such a frequent basis. You would require a consent for making data accessible. And then you have this issue of mixed data sets. So it's not about for a specific purpose, for a certain event that you agree, okay, you can now use my data, but it's more because now we are making it as a subject or a basis of the data economy, and that it's it adds a lot of complexity and a hurdle. Let's say it's not a contrast, but it's a hurdle. And just imagine if every time you used your car, you would have to sign documents for consent, and it may happen that I get killed, and it could be that other people ignore a red light, and it would make life very, very difficult. And considering just the high hopes we are putting on the Data Act and the data economy, I think the system at the moment you need to comply with to share data legally. And as I said, there's also a lot of people who just don't comply with the rules. Is a hurdle, and it's just it makes it more difficult. And yes, I think it was a nice summary by Danielle saying it should be a safe environment. And yeah, I think the other issue, the new user-centric concept, if you touch upon this tomorrow, that's of course a whole new idea of moving the user away from being somebody who just delivers data to giving him control also in the data economy. So basically mirroring a bit the principle of the GDPR.
If possible, I'm happy to address the question on the role of intermediaries, which I think it's can be considered as, to me, as a representative from a platform. So it's a very good question. And actually, I think that we should not come from a place where we exclude by definition some specific business models, because would mean that, for example, users are paying for their privacy, which I think it's not a correct way to depict subscription-based models. If we look, for example, the debate that the publishers are igniting about the possibility to consent for cookie collection or cookie processing, or pay for a subscription, is a very interesting debate, and we should look at this debate with open eyes. We are seeing also, for example, some platforms like Netflix that were based on a subscription model now moving into advertising. So it's not one side direction, is both side directions. And actually, it's very, very important to look at these once again with bright eyes, and not thinking that users by default are not reading, by default are always consenting, by default, if posed in front of an alternative to pay or to have a free ad sustained model, they will go for the free one by definition. Maybe yes, maybe not. Or maybe the percentage of users that will go for a subscription-based model are actually the users that are really concerned about a specific problem.
So there is still a question from the online audience, the one I mentioned about Article 5.2 from DMA. And he's saying, background to the question, the DMA's goal of contestability is clearly addressing potential data-related exclusionary effects. Does this give more room for interpreting specific choice different and distinct from the consent requirement under the GDPR? Marco, would you like to go, or maybe Katie? Okay. We have other people. Oh, sorry. I'm not the best person to this technique.
She can reply.
Is she muted?
No, she's muted.
You need to unmute yourself, Michèle. Please. You
Sorry.
can.
Yeah, I mean, just maybe
It was not
to Christian's question as well. So I think that the trouble with the different meanings of what data protection or privacy mean is that we do have this very specific and precise legal framework, the GDPR, which is grounded in different national legal traditions, which each had different understandings of why there was a need for data protection. Then in the legislative process of the GDPR, there were also different influences and different motivations that led to this sort of like compromise text. So it's very difficult, I think, from a purely legal perspective to say, this is the one underlying objective of data protection law, and we can interpret the GDPR in light of this one underlying objective, and through that then distill its relationship to data sharing. So I think that makes it a bit more difficult. And then I also just briefly wanted to come back to your question about consumer facing intermediaries. So I assume you're mainly referring to personal information management systems, PIMS. And yes, I do share your impression that there's no, that in general, I think PIMS are still a moving category, right? They have very different setups, very different business models, very different even technical tools through which they pursue their goals. I think in relation to personal information management systems, it will be interesting to see what the impact of the draft Data Act will be, because there's certainly potential for them to take on a new significance in relation to the Data Act's IoT regime. So maybe this is something that will look a bit different in the years to come compared to what we have today.
Thank you. Katie, would you like to reply to this first, or are there any other questions?
Hello, my name is Isabella de Michelis, and I'm an entrepreneur. We founded an app that enables the users to manage their consents. And it's very simple. Consent can be very simple if it's automated. So my question goes to, why are we seeing so difficult for people to use technologies if technologies makes things easy, and when they have incentives for making it? So I've heard here in this audience that GDPR is a kind of a difficult regulation to live with, and I keep hearing this since years. GDPR is the most incredible regulation the Europeans have crafted, which opens a choice for users, for people to express themselves. Of course, they need to be given tools to do it. Of course, legitimate interest and contract have been used as more extensive legal basis than consent. But we've seen in practice that without consent, there's no sharing. So we want to have DMA working, we want to have data governance working, we want to have data art working, but we need to go through user consent. And talking to users, it's expensive, and it needs to be crafted really well. Because if companies want consent, they know how to do it. So my impression, this is the question for the panel, are we really thinking that GDPR, it's not maybe the regulation that is the most facilitating data sharing than any other one? Because to share, you need to have the party who shares, who is the data subject. Then you can have a data user and you can have a data holder. But those data holders and user, which are those in DMA, DA, and DGA, comes always after the data subject. So the question is, are we really sure that the DMA is going to work because it's the companies who want to make it work and the institutions? Or should we not really more thinking about making it known how it works with the people? Thank you. Yeah. And I know it's a difficult question.
Let's start from maybe Katie, would you like to reply to the question on the cooperation, on the lack of provision in the GDPR, or?
Yeah, sure. I haven't spoken in reaction to any questions yet, so I can make a few comments in relation to some of the points that have been raised. So firstly, on the issue around whether there is this tension between the GDPR and DMA along the lines of data sharing and data protection, I agree that GDPR does limit data sharing in some ways through principles such as data minimization and purpose limitation. So the principle of data minimization requires you to use the minimum data necessary for the purposes. Purpose limitation requires you not to use personal data for purposes other than those for which they were collected. But as was highlighted by Christian, there are some ways in which the GDPR does require personal data to be shared. So the right to data portability is one of those reasons. The right of data access is another area where personal data needs to be shared with the data subject themselves. Turning then to the institutional mechanisms for cooperating with other authorities. In Ireland, the DPC is a member of the Digital Regulators Group with our counterparts in Ireland who also are involved in regulating in the digital space. So in addition to the examples you mentioned, I just wanted to flag that we also have that group in Ireland. Our contribution via the EDPB to the high-level group under Article 40 of the DMA will hopefully allow the data protection regulators to contribute to the discussion around the interplay between these different areas of law, despite the fact that there is no specific mechanism under the GDPR.
Please, Marco.
Thank you, Danielle. On the question around consent, I think there was maybe a misunderstanding, but I actually support the case that the GDPR is a very important piece of legislation that has to be seen in coordination with the DMA in relation to the fact that the GDPR is offering the possibility to use different legal bases for different specific moments. Consent is a great legal basis, but for example, as the example I made before, we cannot ask consent from a user that we want to make sure is not doing something wrong on our platform, like misinformation or fraud, because that will not be effective since the user itself wants to misuse our platform. So once again, GDPR actually gives the flexibility that the DMA doesn't give us to use different legal bases in specific situations. Then quickly on the point of the data flows, absolutely that's an important value. But when we look, I agree actually the GDPR is more there to allow the data flows under specific circumstances and in a lawful way. When we look at the GDPR, we need to be very careful. The GDPR is, because it's coming from a place where it wants to protect user rights and assure data flows, has very strict rules when, for example, data can be considered anonymized. Do we want to consider the same standard also in the context of the DMA? Probably not, because if data combination and cross-use needs to be as flexible enough to allow contestability, but not put the platform in a position where they cannot offer the services in an effective way, and actually to protect user rights, because you want to anonymize data, and when you cross-use data that are anonymized, there is no anymore the risk that is addressed by DMA. That's a reason of reflection. What I want to say is that we will need to be a bit more, take a step back and looking at GDPR, looking at DMA, try to really take the best out of them in order to, on one side, make sure that the market are fair and services can be, the contestability is there. And on the other side, we are not diminishing the protection of user fundamental rights.
I think we are done. So let's stop here. Thank you all. Thank you. Great thanks to the audience that stayed here. And to our panelists, thanks, Professor Michèle. And for those who are coming for the dinner, see you in about 2 hours. Bye. Thank you.